Next, we come to the registration of a partnership firm. How a partnership firm is being registered. Registration of firm means the recording of firm's name along with prescribed particulars in the register of firms kept in the office of registrar of firm. Means when any partnership firm comes into existence, its name must be registered with the registrar of firms. So section 56 to 71 of the Partnership Act deals with the registration of the firms. Although registration of the firm, partnership firm, is not a compulsory affair, but it is, if it is registered, it can enjoy some benefits which are only for the registered partnership firms and which are missing in case of unregistered partnership firms. That means it's totally optional at the part of the firm. If they want to get benefits of registration, they can register themselves, or if they don't want to get benefits, or they don't care about the benefits of registration, they can avoid it. Non-registration doesn't affect the partnership agreement or other transactions of the partnership. Means if any firm if do not opt for the registration, it would not affect their transactions. But yes, as I have already said, the unregistered firms has some drawbacks, like they cannot file a suit against any person for the price of goods supplied by the firm. They can only the registration is only a reliable evidence of the existence of a partnership firm. How the partnership firm is being registered? There is a process for that, there is a procedure. We will discuss that. A firm may got registered at any time, at the time of its formation or at any time thereafter. Means section 58 subsection 1 says that if at the time of the contract of the partnership any firm wants to get them registered, they can. But if they think so after coming into existence, after 5 years, 10 years, they want to make them register, they can even do that after so many years. What is to be done? An application should be submitted with the fees, requisite fees required for that, and this application is to be submitted to the registrar of the firms, and application must be sent with the provisions that where the business would be situated, what would be the place of the business. And the application form should also contain the documents, the particulars, like the name of the firm, the principal place of the firm, the name of any other places where the firm carry on business, the date when each partner joined the firm. Means it would include the information about each and every partner, the name in full and permanent address of partners, the duration of the firm. And most important, this application form must be signed by all the partners. If any partner not willing to sign this application form, that partner cannot be a partner in the registered partnership firm. Means to be a partner in registered partnership firm, every partner need to sign. And how this process of completion gets completed? There are different views. Means when we say that any firm is a registered firm, any partnership firm is a registered firm, there is a process for applying. We have discussed that process. Since the application is to be submitted with the signature of all the partners, once the application is being submitted, can we say that this firm is a registered firm? There are different judicial decisions regarding that when we say that registration process is completed. Number one, registration is complete as soon as the application form along with prescribed form is deposited in the office of registrar of firm. This was given in the case of JR and OM contractor versus IT commissioner. So this view was given in this case. Once the application is being submitted, the firm will be treated as a registered partnership firm. But the second view in case of CIT versus Jayalakshmi Rice and Oil Mills, here the case says that the completion, the form, the registration is complete from the date when the registrar files a statement and make entries in the register of firm. When any firm, when any entry is being made regarding the in the register of the registrar regarding the firm's existence From that date, the firm got registered. So there are different views given by the different judicial decisions. Now, if any firm once registered wants to change any particular in the registration form, can they change? Yes, there is a provision. They can make the changes. The changes may be regarding first change in the firm name and principal place of business. Being this is a major change, the firm wants to change its name, the firm wants to change the principal place of the business. So in this case, a fresh application is to be submitted to the office of the registrar along with the prescribed fees, as it was done when the firm was once registered. Again, it should be signed by all the partners. It must be verified by all the partners that the firm is going to change its name or principal place of business. Second, change regarding the closing and opening of branches. It can be intimated to the registrar of the firms that firm is closing any particular branch or firm is opening any new branch. Then there is a change in the name or permanent address of any partner, and this intimation must be sent by that particular partner or any agent of the firm to the registrar of firm. If there is a change in the constitution of the firm and its dissolution, so normally firm's constitution changes when any new partners comes into the business. How it changes? Let's suppose there were three partners sharing the equal share of the profit, but one partner retires and a new partner enters, or there is a fourth partner in the business. Now there would be a change in the proportion of the profit of the existing partners too. So there would be a change in the constitution. So similarly, when any partner exit from the business, there is a change in the constitution, and this must be conveyed to the registrar of the firms. Next, change regarding minor partner's decision on becoming a major. As we know, any minor partner can be admitted to the business for the profit purpose only, and once that minor partner becomes the major, then that minor partner who is becoming major now has to convey his intention to becoming full-fledged partner in that firm or not. Next, by the minor partner himself, or he can do it by himself, or any authorized agent of his can convey this. Now I said in the previous slides that there are a few benefits which a registered firm can have. That means there are effects of non-registration of a firm. What are those effects? One, the partners cannot file a suit against the firm or other partners. Means if any of the partner makes any default, then the partners cannot file a suit against the firm or the other partners. Registration of the firm is not possible on arising of any dispute, which means suppose the firm is not a registered firm and any dispute arises, and on arising of dispute, now firm wants to register themselves. So it would not be possible to register the firm once the dispute has been arised. That means the registration firm is possible before the arising of any kind of dispute. So this was clear in the case of Anupurna Fertilizers versus General Store. When suit is filed without registration, it is liable to be dismissed and cannot be rectified by subsequent registration. So the case was decided this way. Second effect is the firm cannot file a suit against third parties, which is covered under section 69 subsection 2. The unregistered firm cannot file a suit against any third party in case of any default. This is clear with the case of Kavita Trehan versus Balsara Hygiene Products. In this case, what happened? A and company, an unregistered firm, sold certain goods to B on credit, but B failed to pay the price of the goods. In this case, the firm cannot enforce its right in a court of law by filing a suit for the recovery of the price, because an unregistered firm cannot file a suit. An unregistered firm can first get registered. If any unregistered firm wants to file a suit, there is a process. They can first get registered. then they can file a fresh suit if the firm, if there is still within the period of limitation, means if there is still a period left to file a suit. Next is the partner of the firm cannot claim a set off covered under section 69 subsection 3. The term set off may be defined as adjustment of debts by one party due to him from the other party who files a suit against him. Let's see the example. A and Company, an unregistered firm, borrowed rupees 10,000 from B, a moneylender. The firm has also supplied certain goods worth rupees 1,000 to B on credit. On firm's refusal to pay the loan, B filed a suit against it. In this case, firm cannot say that rupees 1,000 owed by B to the firm should be set off against B's claim of rupees 10,000 against the firm, because the firm is an unregistered entity and the partner of the firm cannot claim a set off. Now, there are some exceptions to non-registration of a firm, means whether the firm is not registered, even then there are few benefits which can be enjoyed. One, the third party can file a suit against the firm. Firm is not registered, in that case, firm cannot file a suit, but the third party can always file a suit against the firm in case of default. The partners of an unregistered firm can file a suit for dissolution of firm. They can always file for accounts of the dissolved firm or for realization of the property of the dissolved firm. In case of dissolution or its affairs, any unregistered firm can file a suit. The rights of an unregistered firm, all of its partners, are not affected if the firm has no place of business in India. That means if the firm is working from outside India, it can enjoy all the rights of a registered firm. And if the unregistered firm makes a claim to set off and the subject matter of suit does not exceed rupees 100, it doesn't get affected with the non-registration of a firm. The official assignee or receiver may bring an action to realize the property of an insolvent partner